Hello and welcome everyone to our quarterly webinar series on IP issues. Today's webinar is focused on mitigating IP issues in China. And the format today is meant to be interactive and a dialogue. So as you have questions come up, feel free to enter them into the chat box on the side of your screen, and we'll try to address them in real time. And similarly, if there's anything you think would be of interest, even if it's not particularly a question, let us know and we'll also try to address it. And during the webinar, you'll be hearing from two of us today. My name is Gina Cornelio. I'm a patent partner in the Denver office of Dorsey & Whitney. And with me is Lee Osman, who is also a patent partner in the Denver office of Dorsey & Whitney. And we have collectively and individually handled a number of different Chinese issues related to doing business in China. So feel free to hit us with your craziest questions. And I'll turn it over to Lee to get started.
Hi everybody, thanks for joining, and we hope you find this session of interest and maybe take a few tidbits out of it. Over the last 20 or so years, we've been involved in our clients going into China, manufacturing and selling in China, and the interface between dealing with IP rights as they're kind of dealt with in the United States versus China has brought us to have an interest in the distinction between the two systems. And while we're not going to do a compare and contrast today, we thought it might be helpful to go over some of the lessons we've learned in counseling our clients with respect to their experiences in China regarding how their IP is treated and trying to mitigate the issues related to that.
Have you seen a big increase in companies moving to China either for manufacturing or business in general?
That's a good question. I think the biggest increases for me back in the early 2000s, and everybody's there now. If you have a market in Europe, you're probably manufacturing something in China and selling in Europe, right? But any company that wants to improve or increase their market share anywhere, that'll make China and dealing in China a priority. So anytime you're manufacturing in China or operating part of your business there, the IP that you're relying on for that part of your business is subject to risk. And our goal today is to talk about how we manage that risk. If you manage that risk well, it can be an annoyance. If you don't manage that risk and kind of stick your head in the sand, I think it ends up potentially being a pretty negative scenario for your IP. And maybe your IP remains intact, but you end up having virtually no protection from it because too many people are infringing, right? So the business models with exposure in China, we've talked about that a little bit, but it ranges from manufacturing, software, product marketing and sales, industrial processes, even services. Basically every business type, if you're operating in China, will have risks to the value of your IP, will create risks to the value of your IP. So the pathway we wanted to discuss today has maybe 6 or 7 steps, and they're reviewed here on this slide. We'll address each in detail, but to go over them at a high level now, I think everyone needs to have an honest assessment of the environment in China with respect to intellectual property. It's not US, it's not Europe, it's simply different, and I think it's worth doing some diligence on what that environment's like before you make a big investment in China. Relationships really matter in successfully operating in China and protecting your IP there, and minimizing the degradation of your IP value. Relationships are important everywhere, of course, but in China they're different, and I think it's worth exploring the cultural differences and the typical approach to developing and maintaining relationships, not only with your supplier or a business partner, but also with your counsel and even with your competitors. You want to be proactive. We'll talk about that. That does mean we want to get some filings done early and kind of cut off at the pass some typical things that can happen when you start doing business in China. Doing diligence before you get into China is important, and diligence is all around. It's diligence on your business partner, diligence on your law firm partner, diligence on your maybe even the family members of your business partner, and you'll want to make sure to get that started early and pay a lot of attention to it. You might not think you need a sound legal foundation there, but it's important to treat it just like you would in Europe or the U.S., where you want to have a lot of contracts at all levels. Everyone's probably groaning to think about that, and it's not easy, but we found it to be very helpful in a holistic approach to protecting your IP and maintaining its value. The ongoing part of this process for mitigating loss of your IP rights is system security. You need to have regular ongoing checks, both of your processes and of your relationships, to help make sure things are going well and try to forecast or anticipate when things might not go so well. Enforcement is important. You can imagine, if you have a stick and you never use it, it doesn't look like a stick very much. It's an expensive aspect of it. It needs to be done strategically, and this is where having a good team around you can help you pick and choose which type of enforcement to do and how often. And then I think the final step that is more important than it might seem is you want to do a postmortem and on every particular incident if you can, and also on a regular basis. You want to take a look at how your systems are working. Have you had any real problems? Are there areas you can get better at in any one of these earlier items? So trust but verify.
Sounds like a banking term.
For sure.
So I guess getting started on your first keys to success in China is honest assessment. Can you give some examples of the environment and how it's different?
Well, I think, the things we'll talk about here are, as I have in the materials, are generalizations and observations. And my reference to influx relationships really means that these norms are changing continuously, and it's something you have to try to study and learn about. But I think I'm not a policy wonk, but it seems like jumping into a market-based economy so quickly creates a need or feel of needing to catch up, and taking the approach of catching up in an accelerated way might cause some corners to be cut. But that's just my opinion on it. There's less of a belief in the rule of law. Generally, there's less focus on innovation, although clearly companies in China do innovate. That's become a bigger focus as of late. Private property is a concept that's really only been around for a generation, not hundreds of years. There is an older concept that to honor a design is to copy a design. And then relationships take years to develop, and in the U.S. or Europe or elsewhere, you maybe can do a deal on a handshake and paper it up later. That might be the wrong approach. If you had to work in China, you'd probably want to develop your relationship, foresee how long it's going to take to do that, and get your contract in place as your relationship is developing or after it's been formed. Of course, we don't always have time to get that done, but at least if you keep it in mind, you can pay attention to really developing that relationship before you enter the country.
Would you say that you see a lot of problems where companies assume it's similar to the U.S. and operate, not to say that people are untrustworthy or that there's different rules, but have you seen that's been a problem if people are approaching it with the same U.S. or European type of approach that maybe doesn't work?
Well, I think, yes, I have. The larger companies and clients have processes in place to do diligence on their business partners. Where I see most of this is mainly with smaller companies, where they see an opportunity and they act quickly, and it happens to be with a Chinese supplier of a product, for instance, and they go ahead and get that done and taken care of, and they start receiving products from this new supplier, and then they realize that the supplier is selling out the back door, or maybe is selling on a online marketplace with a different brand name, but it's the same product, and and the client is surprised that's happening. And that's where the realization that things are different is kind of coming too late.
Yeah.
Right.
Just want to head it off before there's a problem.
So playing field's different than the U.S. It's good to get to know that. What are the actual risks? So we've seen a variety of these occur. We talked about one just a second ago, but there's, of course, pirated trademarks. There are parasitic brands that are close to the brand you might be marketing or selling it under there. There's copycat products, of course. And, these there's many others. But these result as I guess they come about as a result of odd scenarios you don't find in the United States, like current or former factory personnel and distributors actively going into business with your technology or your products. We often find, unfortunately, family members of folks that we think are on our team are pursuing competitive products with our clients' technology.
And I think tell me if you've experienced this, Lee. There's actually the innovation side. Some of the people in China and manufacturers actually think of themselves as, when they develop these type of copycat products, as innovating and being entrepreneurial in a sense. There's a term I've heard, Shenzhening a product, which means basically to copycat it.
Oh, really?
And
I hadn't heard that one.
I mean, it's impressive. They've actually even copied a whole car.
Yeah, and I see that in our presentation. That's amazing. I think one of the common things that may happen is that your distributor may jump the gun and file things maybe on your behalf, but that can cut both ways, as we'll talk about in a second, where if they file for IP rights on your behalf in an attempt to innovate and protect you, it also binds you to them as the sole supplier, and you can't transition your production away from that company. And we'll talk a little bit more about that here in a minute.
Okay.
You may also find that your products are sold outside of your market, whether under your mark or a different mark. But if your business partner knows that you're going to supply mainly to Europe and the U.S., you might find your products in South America, and that's a kind of an issue that's difficult to find and difficult to resolve, but it can be as subtle as that. One other thing you might find is that your new designs prior to introduction by you end up being new products of your competitors, and that happens way more often than you like. So all of these things we'll talk about in our discussion today will help keep that from happening. Transitioning to the relationships. So again, relationships matter. That we could stop there, and that'd be a true statement, an obvious statement, clearly. But on your team, don't go it alone until you run into an issue. You want to find a trusted advisor, a business associate, a colleague that you've worked with before. Maybe you have to hire that in, or somebody from a trade association that you can get to know that has had this experience of in getting into China or changing your status in China to being more involved. You want to also partner up with a law firm. And I put in Western law firm, and I didn't mean Western law firm. I meant a law firm that has a multicultural experience that includes a business dialogue from a Western point of view, but also knowledge of the Chinese approach to business, so that they can translate, if you will, between talking business from the Western approach and talking business from the Chinese approach, and then help your company assimilate the differences and identify the problems. So I didn't want to imply only hire somebody from the U.S. or Europe for your work in China. That's not it. It's more about having a multicultural approach to their business practice. It's really important to get an advisor, a legal advisor, on your team to help with that. With respect to your business partner, you want to plan to invest time and effort to develop a strong relationship there. And the clients I have that have done that a lot, I would say spend probably a year developing the relationship with a personal visit every other month, it seems. It's quite a bit of effort, but pays off.
Mm-hmm.
Being proactive. So you always want to be proactive on your IP, right? But that's especially important here. You want to register your IP, whatever kind it is. You want to register it and take action to get it going before you start prototyping, before you transmit files for review by your business partner, so your vendor. You want to be prepared to file more than once if there are changes to your initial product or product design changes. You want to do this in order to predate wrongful registrations by your business partner, and also to preempt kind of the hostage scenario I referenced before, where your business partner might file prior to your filing, since China is the first to file scenario system. Their filing will predate yours, and your filing, even if the rightful filing, won't have the ultimate rights in China. So if they have the ultimate rights and you need to move manufacturers, they can block you from doing that. So you want to avoid that scenario by preemptively filing.
We have a question. Do U.S. filings, are those sufficient to provide that predate?
They are. Yep, they are. And what we've done to help even accelerate the protection is to not wait your statutory time limits to file in China, but go ahead, file in the United States, and then file in China the next day or the next week, so you don't have to prove anything when you get to China and somebody else has preempted your filing, even if you own the priority date. So let's see, types of rights to consider. We could talk forever on each of these, but generally they're copyright and software. You want to register those. Trademark, service marks. Do that in both Chinese characters as well as the English or other language that you might want to use the mark in China. Patents, we want to get those filed, whether they're invention patents, utility model, or design patents. Trade secrets, you want to identify those trade secrets and make sure you understand how they're involved and implemented within your business practice in China, so that you can then know if they've been taken. And domain names and internet keywords, of course.
Do you have some benchmarks, for considering when to register IP, to be able to predate the wrongful registrations, but also, in a typical product timeline?
Yeah, I think it's important to, get to your product target design stage, and then when you think about filing in the United States, that's effectively when you should start filing in China. Filing in the U.S. first, of course, with the U.S. inventor. If you happen to have a Chinese inventor, file there first. But then file promptly in China after you file in the U.S. and before you do your prototyping, before you transmit drawings or solid models, before you transmit any of the IP you might need to use in your business to China.
We have another question. This is related to, let's say you have a marketplace that's only in the U.S. You do manufacturing in the U.S. What type of strategy makes sense in terms of enforcement, or I guess just protection in China generally, especially if there's instances where there is apparently a marketplace for your products in China, even though you don't sell in China?
Well, that's a very good question. So I think that briefly, I think the strategy there is you would do a full range of filings in China, mainly to protect against you being held again hostage by your current supplier. You want to be able to move and change your business partner if you need to. Mm-hmm. So you want to file there and assert your ownership of your IP that you need to have manufactured and sold back in the U.S. You can also then be in a position if either if you move into selling in China, or if the sales in China that you don't care about right now become something of a problem for you down the road, mm-hmm. You'll be in a position to better assert your rights in China.
So I suppose it's always the age-old issue of patent rights require somewhat of a crystal ball, and if you think China might be an issue or a potential market, you have to file there before you care.
That's right, and I think you have two reasons to care in China. One is if you're producing there only, not selling, you need to protect your production source from effectively overtaking your right to manufacture by preemptively filing your IP. And then the other is if you end up going to market in China, you want to have that all set up, because once those public disclosure dates pass, you can't file any longer.
Yep.
Recording rights with customs. Sorry, one last note on this. It's important, but you can record your registered IP rights with customs in China, and you can record them both for exports from China as well as imports to China. That's interesting, I think, and important to know. And that's we'll talk a little bit more about that later, but it can be a pretty effective tool to help yourself during enforcement. So back to diligence, or on to diligence. So diligence basically is an effort to establish trustworthiness, and these are done through background checks, online research, and it really needs to be done by your Chinese counsel. They have the tools and the ability to find information that I found it very, very difficult to try to do from the U.S. But you want to perform diligence on your intended business partners, their past business associates. You want to do some diligence on their past businesses. You want to look at family members. There's a relatively frequent occurrence where when things go bad, there's a family member involved. And all of this is to try to avoid, ultimately, I note trade secret leakage, but also any type of misappropriation, whether it's of a registered right or trade secrets, to being used in a shadow operation.
A question,
Yeah.
It looks like, kind of doing diligence on family members seems a little bit creepy. Do you find that has it been warranted?
Unfortunately, yes. It is creepy, and I might sound a little callous to it now, but we've been dealing with it for 15 years. It's just kind of another thing on the checklist. So family organizations are very, very tight, and businesses are often controlled by families. And unfortunately, it's something that would be important to do.
And we have a follow-up question. I think you may have addressed this briefly, but what's the correct route to go about getting this type of information? Is that through somebody in China? Who would that be?
Oh, we found that the holistic approach is to have the background investigation run by a Chinese law firm, and the law firm will do its own research, but then also hire private investigators on the ground to go actually do shoe leather work in their investigations. It's not that expensive, but it's very productive. You can productive as far as learning information that you want to know. You can find out people's habits of patterns, what they do during the day, and who they visit. It does seem creepy, but if you're going to invest a lot of money there, it's worthwhile.
Yeah, makes sense.
I also wanted to note that it takes a while to develop these relationships, and you'll probably have to get into a business relationship before you feel totally comfortable. If you team with your Chinese counterpart and make joint decisions with them on how to market, how to develop products, and have them involved in some of your business decisions, you want to do some diligence, verify and confirm the suggestions they're making as being pertinent to the market you're in China, and that means actually giving yourself some time once you're thinking about making moves suggested by your business partner there to go and get some third-party confirmation of that. And that could be, again, through your business advisor you have a relationship with, or with your law firm or other consultant.
We have another question, which is, are there any special considerations for particular types of business sections? The example was biotechnologies.
I have to say I do mainly work in the consumer product area, but I think you're right that there are different circumstances for each different sector. I think financial services would be a big one. I think biotech would also be a big one. I've delved a little bit into medical device type business sector in China, and it ended up being basically a full left-hand turn from our normal approach for non-medical devices. So I would say yes, there would be different considerations, but all with the common thrust here.
And then one other question we have is will there be, this is kind of unrelated to the topic, but there will be a recording, and I'm not sure if there will be a PDF available, but you can feel free to email one of us afterwards, and we would be happy to give you a PDF.
Finally, on diligence, anytime there's type of an ownership position or transfer of ownership of whether it's IP or manufacturing equipment or computer systems, you want to look into the chain of title and any encumbrances, and do that very, very carefully. And again, you need to rely on your Chinese counsel for that work. So on to the sound legal basis, and I'm a lawyer, and it shouldn't seem funny that I would suggest we use a contract, but lots of business gets done in the U.S. with form contracts or even on handshakes, and it often is done successfully and of course without any problems. And that can happen too in China. I have several smaller clients that have been, without my knowledge, which is fine, getting products made in China and have not had any trouble, and they haven't had any contracts. But I don't think they're big players necessarily, and have probably, their products might be so unique they're not as maybe interesting for sales in China. But in any event, we do want to use contracts as kind of the reliance on IP, relationships, and contracts are the main triumvirate for having a successful relationship there and protecting your intellectual property rights. We want to have contracts at all levels with all entities, and we need to make sure to talk about and cover important terms like specific damages, indemnities, ownership, termination, destruction and handling of mold material if you have that, possession of product design and production information. What happens with that information if your relationship terminates? Those are all things just like you would in the U.S. contract. You want to make sure that they're in your contract and with your Chinese partner.
Do you have any specific thoughts on what type of language the contract should be in? Is there a preference?
Well, I think it preferably be in both. Everybody's probably seen a dual column contract. One side's Chinese Mandarin, one side's English. We've been successful in enforcing contracts that are only in English, but that's a little more dicey. And then, of course, if it's only in the Chinese language, that has to be a pretty special circumstance for a U.S. company to do that. I'm sorry. I was just going to say that one common distinction here worth noting between U.S. and many places in Europe with respect compared to China is that inventions created by or IP created by Chinese employees don't automatically always transfer to the employer. So that's something that typically automatically happens in the United States and many places in Europe, but it's not typical in China.
So that's why one of your key terms would be IP ownership.
Yes.
So we have another question is, do you have any general thoughts on choice of law and forum for Chinese suppliers and service providers? That's
always a hotly negotiated point. We try to make it, California seems to be a pretty acceptable place for Chinese producers or manufacturing companies to be accepting of that. We don't often see a request or a successful request for it to be in China. Hong Kong is also another place that has some very good business laws that is often a good place to be for that.
That makes sense.
A little bit more on a sound legal basis. So of course, get them in writing. Specific punishments. That was a draft word I used. I didn't think that would make it into the final, but it's not true. Punishment's the wrong word. But you want to have some known defined action that would have to take place. for IPR breaches. And they can be things like just proof of destruction of the mold, or you can even try to get some kind of compensation, but it really needs to fit the situation you're in and the type of product and market that you're in. So, but don't hesitate to push on that. You want to have all your agreements with your employees that do R&D, with your licensees, suppliers, and they should all include clauses protecting your IPR. Don't hesitate to use patent type markings, notice markings for whatever type of IP you're contracting about to help create knowledge of the IP rights.
And we have a question about if IP rights don't transfer to the employer, what's the mechanism for doing that?
Oh, I'm sorry, that's a great question. I should have followed up with that right away. You want to be sure to track when that IP gets created, and then if you decide to act on it, you want to get an assignment from the employee to the employer in writing, and that's how it would transfer legally. So on to system security. This is something that is best done in conjunction with your business partner in China. You need their assistance and help in implementing an effective system here. But one thing it does is it establishes an expectation and a culture in your relationship of the fact that you care about how they handle your business. You care about how they handle your IP, how they handle your business terms, how they handle your relationships. And if you start early with working together with them to get a system of checks and balances on how to monitor their handling of your valuable information, that will only help you down the road. There won't be any feigned surprise that that when you show up and say, hey, please don't use our technology in our competitor's manufacturing line on the floor above ours. They can't say, oh, we didn't know you didn't want us to do that. So just say it up front. You want to identify and track your IP. You want to limit access. That all makes sense. And disclosure to sensitive business aspects and files. You want to control production. Here, this is an important one, and it's hard to do, but there are ways to do it. But you want to keep folks from taking spare products in their gym bags home to the dormitories on the business site that night and stockpiling those to start a little company next month. That's happened.
Didn't you have the one with people putting parts in their pockets?
Yeah, just walking out the door with parts in the pockets over years, and that ended up creating quite a inventory for them to work from. So you want to pay attention to those things that you just wouldn't think of doing in the United States so much, but you want to pay attention at that level. You want to have physical security controls on access by employees and visitors to your portion of the facility. Undoubtedly, your partner very likely will be helping a competitor of yours build a product, for instance, and it's not unique for one floor to be company X and one floor to be company Y and the next floor to be company Z, all manufacturing a similar product. And because of that scenario, you want that expertise. They have the expertise. You might decide that's okay, and you don't have enough production to fill an entire plant's capacity. But if you get into that scenario, you need to be very adamant on system controls and access, that there's no cross-pollination of technology or information between the floors. You want to.
Oh, do you have some examples of how you can, limit this access? I think you mentioned security locks for the doors, but for the, electronic information.
Yeah, one thing I've seen that was very simple and helpful is everybody has to use a clear bag when they're coming into work, right? So they use a clear backpack or a clear bag of some sort for their personal belongings while they come to work. Another thing was removing all the flash drive access off of your computers on the workshop floor. Get rid of the USB drives on the computer so that there's not an easy thumb drive insertion, copy all to your thumb drive and slip it into your back pocket. those are pretty simple. Wi-Fi restricted access is key, and but the physical and high-tech versions of locking things down is very important. When I've been on a couple audits of these for clients, and it to me seems like an affront to a person's employment when you lock it out so tightly. But it's different there. The employees just kind of go along with it seems. So while it might seem a little draconian from our typical point of view, these are all important factors to not be bashful about it implementing. Mm-hmm. So the SNAP audits and SNAP inspections, the audits, I think I intended that to mean of the business processes, and then the inspections would be of the physical manufacturing space in that scenario. I think those are important to be sure you implement and have done by an independent party or by maybe an employee or a consultant that is beholden only to you or your company and not part of your relationship with the supplier. But you want to build into your contracts the ability for somebody that represents you to walk in and go down the list and make sure that they're abiding by all the terms you agree to for the security access and protocols. Again, it's creating a culture. If they know that this is going to happen, they're going to try to work harder to make sure it doesn't happen. Mm-hmm. I threw a little bit of a laundry list at the bottom. We've talked about some of it, restricting access. I think maybe an important point, if it's possible, is maybe split your strategic processes and your source of key components to multiple suppliers. That's an excellent way to make sure that no single party has all of what it takes to make your product or copy what you're doing. Minimize inventory, monitor. Nowadays, I think automated systems are so popular that you can control and monitor use of the important tools. And then, you can rely also on the typical approach that many of us take to put in anti-counterfeiting elements like RFID tags and fingerprints in software, things like that. So the next leg of this mitigation effort is about enforcement, and this is where I typically find myself kind of not wanting to talk about, just because it's could be the expensive side of the process, and it's fraught with uncertainty. But you don't want to play whack-a-mole. That's not very helpful. But you do want to enforce in a manner that when you do find a problem, people understand that you take action to some extent to address it. And again, it's about creating a culture that maybe you can become or create a deterrent reason for someone to go copy somebody else's product because they know that you're going to chase them down. Now, it has to be done realistically. It has to be done within your business plan, and it shouldn't be done willy-nilly. But it is something you should enforce. You should try to do by enforcing on occasion when you do find a significant infringer.
Do you think that this is something companies should budget for as part of their China strategy?
I think yes, but those contingent budget categories aren't often acceptable to the finance people at companies. So those are hard to do. I've seen them budgeted for, of course, but I've also seen that budgeting process get a little easier after the first incident of needing to enforce, and then you kind of realize, there is an incident of maybe one every year or 2 or 3 every year that we have to spend up to a certain amount on to pursue. And I have to say, it's not that litigation is ever satisfying, but I think if you're looking for closure, the litigation and enforcement type work in China is not likely to give you much warm and fuzzy on the closure part, because many times these guys just kind of disappear into the woodwork, and that kind of counts as a victory, though, because you've gotten rid of them for at least 6 months before they set up shop somewhere else, right? So enforcement can be formal and informal, and the informal part, I'll just touch on briefly, but informally, I think that's mainly figuring out where you can go to foresee who your competitor is going to be that are improperly copying your IP or pirating your products. And that's traditionally trade shows. And trade shows are huge in China, and they're all based in the regions that specialize in the particular type of technology that you're interested in or that your product it falls within. And, going to the trade show itself, I have clients that do that on a regular basis. Clients have done it on an occasional basis. And what they found is that while it feels good that they're doing it and they're being proactive and taking action, and there are mechanisms at the trade shows in order to help you approach and provide notice to and even letters to the infringers you find, you don't get to that closure point ultimately down the road. But what you do after a few years of doing this yearly visit to the trade show is you can tell if there's a trend of increasing or decreasing product copying, that you notice at the trade show, right? And that in itself can be helpful for a client to understand.
Yeah.
Have a feel.
Help them set up their strategy for enforcement or other diligence.
Yep. The more formal approach, is basically taken upon in three different manners. One is the administrative action, one is a civil court action, the third is the criminal complaint. I think of course these can be expensive. The return on investment needs to be managed and monitored, and you need to select your route depending on the nature and case of infringement. It's very fact dependent, but you can do this relatively inexpensively compared to the U.S. certainly, and we'll go through some of these approaches here. So the administrative actions are taken basically through two different bodies, the AIC and the QTSB, the Quality Technology Supervision Bureau. They're relatively inexpensive. The actual involvement with the AIC is relatively inexpensive, and it's relatively quick. I'd say maybe 3 to 6 months once you get them engaged. They primarily execute raids on behalf of you based on the evidence you give them. The secret sauce here, though, is the investigation prior to getting the AIC involved. You need to do quite a bit of investigation. There is no discovery in any of this in China, so you have to go back to your private investigator and figure out, how do we find where this product's being made? How do we find who's doing it? You have to establish the evidence, get it validated by basically a notary, if you will, and then have your ducks in a row before you go to the AIC, lay out your case, and then they plan their approach.
Is this type of investigation something that a Chinese law firm can help with?
Yeah, it'd be all run through the law firm with them likely hiring a private investigator to do that shoe leather work. And quite a bit can be done online, but a lot of it is sitting in the car taking photographs. Oddly enough, it feels kind of James Bondish. So the cons are, and I don't want to hammer on this, but there can be some tipping off at the local level. The AICs are all local, so you go to basically the county where you find your infringer, and then the local AIC would then execute the raid on your behalf. And we've seen scenarios where, oddly enough, the manufacturer is gone on the day of the raid, or there's much less volume at the facility than our investigations suggest that there should be. And that's very disappointing, and that can be due to some local shenanigans. Penalties can be applied by the AIC to the defendant or to the infringer, but they're not massive penalties, and they're not much of a deterrent, and damages are not likely available for the IP rights holder. Customs actions. So if you record your IP at customs, that can be pretty effective. The key to having that be effective, though, is educating customs where you've recorded, your IP rights, educating them on your IP so they can see it. They have lots and lots of recordings that they have to keep an eye out for. And then it's most effective when you can pinpoint which border or port that these infringing goods are being exported or imported through. And that's, again, back to your investigations prior to bringing any kind of action. That would be a natural thing to do that many private investigators and local Chinese law firms are knowledgeable about and can guide you well to collect that helpful information. Enforcement in civil court actions, this is getting better. I'm an optimist, and I think it's getting better. It's certainly gotten better in the last 20 years. Just recently in January, China promulgated the new unfair competition law. It's actually called the anti-unfair competition law, which makes it comport much more closely to the U.S. and other countries' unfair competition laws. So it covers more than just famous marks and expands the actions that can cause liability under this law significantly. It's brand new, so it hasn't been tried yet, but I think this is a positive move, and this would be done in the civil court. There's basically, it's basically a parallel system to what you might be familiar with in the U.S. Damages and injunctive relief are available, and again, here we go. A discovery process is non-existent in China, so we're right back to our private investigator, and getting this private investigator going early and keeping him on retainer when it's worth it is a good plan for generating the evidence that you need to bring your case in court.
Do you think that, in your experience, has that generally been then, one discovery is often one of the high costs of doing litigation in the U.S. Does that help make the Chinese process somewhat less expensive, or is it just other factors that help to make it a little bit less expensive than in the U.S.?
Well, I think it's much less expensive because of the lack of the discovery fights that we see in the U.S. Yeah, so that's the overwhelming thing. They have bifurcated proceedings in China for patents, for instance, where your infringement's in one court and the validity is in a different court, and there's kind of a race to a decision. Even together, they're less expensive than the U.S. litigation, but the whole crux of your enforcement comes down to the quality of the evidence you gather on your own prior to bringing the action. So that's really an important element. The costs are high, and again, it's not as high as the U.S. There are not great damages, although that's changing too. Recently, the Beijing court has decided to increase their limit of damages awards to IP plaintiffs up to, I think, 3 million yen or something like that.
Yeah.
But in any event, there's an improvement there. Lack of independence of judiciary in many local courts. That kind of means there's a patronage to the more the Court of Appeals, if you will, in their system, and the local judges care a great deal about what the higher judge who will hear the appeal will say about their opinion. So you can't count on the judges being entirely independent in their analysis. So there is an option for criminal actions in certain scenarios. You can get if it's just a blatant breach, you can actually get the Security Bureau to take your case. The evidentiary standard is extremely high, but it's a pretty good deterrent if you can get that to stick. There can be fines and imprisonment. I've not done one of those personally. I've looked into them, and the standards are so high it just seemed difficult to get there. You kind of give up other options if you do that.
Sure. Something to know.
Yep. So here's, we're near the end. The review and improve step. This is something that I have to say a lot of people don't do. And when we've done it with clients, it's very, very helpful. But you need to keep records of the key actors and key actions and coincidences before you have a problem. You want to know who you're dealing with and what their relationship is to your business. And then if you do run into problems, even if it's something that you don't enforce against or you don't take significant action against, be sure to update that list, because you need to use that list down the road and create the information to help remind you that 3 years ago this same person ended up showing up as a potential unauthorized distributor in in this other part of my business. Now they're showing up in this second part of my business 3 years later. Why is that connection? Is that a coincidence? And you can kind of more efficiently investigate that and not start from scratch.
Would that be something, if you start with the initial diligence that you do before kind of getting anyone on board, that you just update?
Well, yes, yeah. Yes, that's what you would start. Think of it as a crime show whiteboard when you've seen kind of all the players in a scenario that the police are looking at. And again, it's not punishment and it's not crime necessarily, but it's kind of that type of a diagram where you look for connections and don't assume things are coincidences. It is a lot like a little spy novel sometimes. So keep an eye on analyzing your records and procedures, and look for ways to improve your processes.
Let's turn it back to you for
some more. Right. Well, thanks. So the last part of this is just a quick run through kind of the benefits of being proactive. We talked about early registration of your rights and some of the benefits there, and why you should do it. And this will hopefully bring it home a little bit why you do want to get your IP rights going before you enter China in a big way. So we'll start with trademarks first. So trademark registration is 3,000 or less and good for 10 years, renewable for 2,000. In a trademark dispute problem, you can do an opposition versus a pirate application. If you have a registration, it's maybe $5,000 to address that. If you don't have a registration, it's $10,000 or more if it's even possible. Trademark cancellation versus a pirate registration where you're actually trying to get rid of their trademark entirely. If you have a trademark registration, again, it's about $5,000. Without a trademark registration, they say $8,000, but I've seen them be much more expensive, if at all possible, again. An administrative raid, if you have an actual registration, it's a pretty efficient process. Now this $10,000 does not include the investigation. I would budget probably another $10,000 or $15,000 for the investigation. But once you have all the material pulled together and you go to the AIC, if you have a registration, it gives them a much better sense and comfort with the fact that you actually have a right that they can go and enforce and not get in trouble. So that's why it's less expensive. If you don't have a trademark registration, again, not likely possible, or much, much more, because you have to work a lot harder to convince the local AIC to take your case. Infringement for trademark issues in a court when you have a registration is about $20,000 if it's substantially uncontested. An unfair competition action because you don't have a trademark registration is $30,000 or more, and I've seen it be much more than that, and it varies with the evidence. So I think with this new law also for anti-unfair competition, that'll be used in conjunction with actual trademark enforcement, probably pretty effectively. Moving to patents briefly. So there's design patents, utility patents, and utility model patents, and we could talk all day about, again, any of this, but quickly, design protection covers the appearance of something, the aesthetics of it. The utility model patent is basically a patent that provides exclusivity for a shorter period of time than a utility or invention patent. So a design registration is 2.5 years. I'm sorry, 2.5 thousand, about a year and a half to get. Its term is 10 years from filing. Utility model patent, which is, remember, a patent light, is not very expensive to obtain. You have to draft it still, but it's only about $3,000 and about a year to get your utility model patent. Now that is not examined, so before you enforce it, you need to get it examined. That takes an additional 6 months, and you can do that while you're doing your private investigator work prior to bringing a suit. Have
you found that utility models, have been sufficient though for at least a deterrence?
Absolutely, yeah. If you look at the filing numbers, the native Chinese inventors file way more utility model patents than they do full utility invention patents. and that's because they're inexpensive and they're kind of a latent threat. They can be very effective, or they can be not effective at all, but you're not sure. And you want to be cautious in this area because of the potential liabilities. So you pay attention to those utility models almost as much as an invention or full utility patent.
And there's a quick question, just a high-level distinction between a utility patent and a utility model, as compared to a U.S. patent.
Sure. So a utility invention patent in China is the equivalent of a utility patent in the United States. Think of a utility model in China as basically a filing of a regular utility patent in the United States, but it does not get examined. So it just gets published, and the claims are whatever they're filed as, and there's no evaluation of the merit of the patent. It's just a notice to the public that there's somebody claiming protection of a certain area of technology.
Maybe like a publication?
A publication of an application, yeah, a utility application. And before a utility model could be enforced, it has to be sent back to the patent office, and they go through a brief examination process to validate it to some extent. It's still not as solid as an invention patent in China, but it's very enforceable and can be very effective, and it's much less expensive.
So it would be more kind of delaying the cost until you need it for enforcement as compared to an invention model or invention patent.
Many clients decide to just go utility model with all but their most important patents in China.
That makes sense.
So enforcement of patents, similar to trademarks, you can use the AIC for an administrative raid. Again, that's local, it's relatively fast. If you have good design protection, that can be very effective because it's inexpensive to get a design patent, it's relatively quick, and then what's really nice is that the guys at the AIC can look at a picture and see what it looks like and compare it against the potentially infringing product and confirm on their own infringement as opposed to reading detailed patent claims. You can use detailed patent claims, it's just harder to do and more expensive because of that. The court, you can of course enforce patents in their civil court system. It's expensive, not as expensive as the U.S. I would say my experience is $100 to $350, depending on how hard everybody fights. And it's you get to the same point as you do in the U.S. at about the same time, but you don't have as much opportunity to get damages for infringement, but you can get injunctions. You can get damages, you just won't get significant damages.
That makes sense.
And I think we're open to questions. Thank you, everybody, for listening. I hope it's been helpful.
Yes, and so here's a quick note on CLE. Here's, as shown on the screen, to go ahead and email these two email addresses for the CLE certificates for those who complete the form. And I think we have one kind of question in the queue, which is for some industries where use or may come later from the initial trademark or branding of a product, does it make sense to file in China, after you've proved you have a product, or as early as you can?
I have to default to as early as you can support a filing in China. The risk of waiting until you have use in China is that somebody picks it up and files before you, and that just isn't worth the risk.
Okay.
So, all right.
Great. And there's a question on the CLE forms. No, Dorsey will not be emailing you for the CLE forms. You'll have to email, again, Michelle Hubble at her email address here, and she will send you the CLE certificate. And as we noted at the beginning, this is a quarterly series of IP webinars, and here is our next one is on the litigation impact of the fancy new technologies, AI, smart devices, and of course the hot topic, cryptocurrencies.
And
that's set for March 28th, 2018. So thank you all.
Thanks, everybody.